but there's been no notice and no due process opportunity for the defendant to object. So the bench warrant would issue, he'd go into custody, and I guess then we'd have the hearing. I would have the hearing before I issue the bench warrant or modify the bond. This is an emergency record in the matter of People versus Logan Thomas. File number is 243131. Ms. Davis has filed a motion to cancel bond. Mr. Thomas is not here, and his attorney of record, Mr. Ross Truckee, is not here. And I don't know that they even know of the hearing. I set it about an hour and a half ago for 10:30, and I don't know that anyone knows. So Ms. Davis has filed a motion to cancel bond, indicating the defendant had been arrested on a serious charge of driving suspended, causing death for a crash that occurred on December 2nd. Defendant was able to post bond on December 13th and release with conditions of no controlled substances and testing at the day reporting center. According to the motion, the defendant submitted a specimen at the day reporting center on December 16th. On December 19th, according to the motion, the lab report came back indicating the defendant was positive for methamphetamine. The defendant was released on the 13th. So presumably he would have not been able to use methamphetamine between December 2nd and December 13th. But his sample of the 16th, according to this, is positive for methamphetamine. This is interesting. This test came back, but they're still waiting for tests from the state police.
Nope. Actually, I'm sorry, maybe a little confusing the way it's written, because the state police result came back yesterday afternoon as well. So it just happened to be that both lab results came in same day. So we do have the lab results from the date of the crash. And that is indicated in paragraph 6 of the bond motion.
All right. I didn't see that. It is believed that the defendant was under the influence of methamphetamine, amphetamine, fentanyl, and morphine at the time of operating the motor vehicle on 12/2.
So we do have the lab result back for that one with the.
All right, and it does confirm the presence of those substances?
Yes. The methamphetamine was in excess of 300 nanograms per milliliter.
All right, and prosecution plans to amend the complaint.
Yes.
So the paragraph 13, defendant is risk to the public due to his continued substance abuse and disregard of the law regarding operating motor vehicles safely. So she has filed a petition and affidavit for a bench warrant and an order forfeiting bond. There's no legal authority cited in here anywhere. I'm not sure I have the authority, absent any notice to the defendant or his counsel, to summarily revoke his bond. Do you have something that I could hang my hat on?
Sure. Your Honor, the court at any time is able to look at the pretrial release conditions, and I will. 6.106. And in this case, we do have a case that is very serious, being that there was the death of a child. And the conditional release is to ensure the appearance of the defendant and to reasonably ensure the safety of the public. And the court can order that pretrial release on the condition or any combination of conditions that the court determines are appropriate. The court did put conditional release terms on him, and he has not complied with those. So as far as revocation and appealing or modifying that release decision, we can file a motion to do so, and the court may decide to reverse that decision.
I set the bond myself.
Yes.
I believe we're here in open court, but I'm reluctant to do an ex parte revocation of bond and a bench warrant without any notice to the defendant or counsel. I'm going to set this for an order to show cause as to why the bond should not be revoked.
Your Honor, can I have just one moment? I have one other spot to check. 6.103 talks about the immediate revocation. Under 6.106H, the modification of a release decision prior to the arraignment on the information. So prior to the defendant's arraignment on the information, any court before which proceedings against the defendant are pending may, on the motion of a party or its own initiative, and on finding that there is a substantial reason for doing so, modify a prior release decision or reopen a prior custody hearing. And I guess we would state that this is a suitable reason to have this done. We do have laboratory testing, not only from the date of the incident, indicating that he is alleged to have drugs in his system at the time, which is going to increase the penalties that he may be facing, which makes it a consecutive potential for the driving while license suspended causing death and the OWI third or subsequent felony causing death. And he has prior possession of methamphetamine charges on a conviction. He has prior charges of analogs, which are what the other items were in his blood. Either the fact that he had a period of what would be presumed forced sobriety while he was in jail, and then within 3 days of release on a very significant amount of bond, he's alleged to have tested positive, and they don't send it to the lab if you admit that you use. And I guess my concern is that DRC, the policy or procedure that they're using apparently is that they were just going to talk to him next week about it and then send over the violation. And in cases like this, where we have the very high potential for somebody to be seriously injured or killed, if I can't trust that the defendant is going to not use drugs, it's not much of a stretch to say we can't trust that he's not going to operate a motor vehicle. He is still working in St. Joseph County, a very short distance from where the victim's family resides. So there is a concern that he's continuing to come in and out of St. Joseph County and that he is still using illegal drugs. Thank you.
All right. Well, I certainly agree that I have the authority to modify a bond and conditional release, but I don't know as of whether, I'm not going to do it, ex parte without notice to the defendant or his counsel. It says you file a motion which presumes that there's notice to the other side. I certainly have the authority to modify the bond, but there's been no notice and no due process opportunity for the defendant to object. So the bench warrant would issue, he'd go into custody, and I guess then we'd have the hearing. I would have the hearing before I issue the bench warrant or modify the bond. So
and I guess this was probably should have been marked as an ex parte, being that we believe there's a substantial risk of harm to delay these proceedings in order to give him that due process. And again, this isn't something where we have just hearsay or we think that he did something or it was a no contact and we think that maybe he had contact with somebody. this is a drug test that was lab confirmed from after he was released on bond. So again, certainly respect the court's decision. Just wanted to give the opportunity for the court to treat this as an ex parte, set it for a motion as soon as possible. But for the safety of the public, we believe that he is a risk, and based on his prior history, his failure to appear prior, the significant increase in the penalties that he's going to be facing with the additional charge, we would ask that the court issue an immediate bench warrant and bond forfeiture. Thank you.
All right. Thank you. He was charged with driving suspended with a death. That was what was known at the time, and I certainly concede, and I said this as we adjourned this matter. It takes time to get the autopsy report, to get the laboratory reports, get the accident investigation reports. It's very difficult to do vehicular homicide cases when the defendant's in custody, sometimes within 12 days of the arraignment. So the matter was adjourned. There was suspicion that there was methamphetamine perhaps used. Whether that's a fact or not, I don't know. But now, according to the plaintiff, that is confirmed. There's no indication he was driving. A very high percentage of our methamphetamine defendants with a condition of bond of no use of methamphetamine test positive for methamphetamine. Some of the old bond conditions did allow for an immediate arrest under a specific rule, and the Supreme Court said you have to provide more due process than that. We said just do an immediate bench warrant and then have a hearing later. Problem is, who is here next week?
Josh is here in person. I can be here virtually at any point. I will make myself available whenever the court is. Monday.
I won't be here Monday.
Or we could, I don't know what your honor's schedule is for the rest of the day.
I'm going to set it for Thursday, December 26th at 10:30. Defendant represented that he was going to retain Mr. Marcoux, but there's a word in there, retain, which includes the payment of fees, and I would assume they would be significant for this type of case. He was advised, and Mr. Truckee was advised, that until further notice, he was still attorney of record. So I'm not even sure who his attorney is, but if and until Mr. Marcoux files an appearance, his attorney of record is still Mr. Truckee.
My understanding is that we received in our general email a substitution of attorney from Mr. Marcoux late yesterday afternoon.
All right. Well, it hasn't made it to the court yet, but it sounds like it's on its way. Anyway, that's what I'm going to do. I'm going to set this for hearing. I'll be here. I don't want to dump this on Judge Pattison next Monday morning, plus getting notice to anybody between now and then. So set for emergency hearing Thursday, December 26th at 10:30. I might be more inclined to issue an immediate warrant if there was evidence the defendant was driving. But when he was here the last time, I believe he had a driver with him. All right, December 26th. You may appear by Zoom, or Mr. Robert may appear.
Thank you, Your Honor.
All right, we'll send out immediate notice. All right, thank you. Laura, would you come get this so we can get that notice out immediately? Send it to both Mr. Marcoux and Mr. Truckee. Thank you. All right, thank you. We're going to switch gears back to the more mundane matters of